Hey NoteTakers, welcome to my YouTube channel. If you're a returning viewer, thank you for tuning in and welcome back. If you're a new viewer, welcome. I hope you enjoy the videos because we have fun this side. If you're a subscriber, thank you for subscribing to my channel. If you aren't a subscriber yet, what are you waiting for? Click the subscribe button to join in on the fun. Don't be shy. Alrighty, let's get into some case law. So in today's video, I will just be discussing my background. I'll also discuss my disclaimer, the playlist this video will go under. I will be going through a case by applying my 3 model case law steps, and then we'll have some closing remarks. Just some background on myself. My name is Ria Beatrice, but I prefer Ria. I am currently a 4th year Unisa BA law student, just wanting to engage with other law students, individuals who are lovers of the law, soccer fans, and to connect with viewers from around the world. If you have any content suggestions or just wanting to reach out, feel free to email me at rianoted@gmail.com. Again, my channel email is rianoted@gmail.com, where you can share your law student experiences and share some feedback. Don't forget, make sure to check my post section on YouTube regularly. I posted this morning. I use my post section just to share what kind of videos I'll be recording, or if maybe I'm not recording. But yeah, my YouTube post section is where I communicate my videos. So this morning I posted a post saying that there's a new video out tonight, i.e. this video, which is about continuing to going through a second case that further explores the Tammy Taylor South African mess. So make sure you interact with my post section regularly, comment, like, share, subscribe. I just wanted to say thank you to my subscribers. It really, truly means a lot. I know my videos aren't getting like hundreds of views, but the little views that I am getting, I really, really appreciate. So thank you to my subscribers. Thank you, thank you, thank you. We're on the road to 450 subscribers. And let's all say my channel mantra: Ria Notes will grow, Ria Notes will do well, and Ria Notes will reach more people. Okay, just as a safety precaution and trying to be safe legally, I have this little disclaimer. I am discussing cases in my capacity as a law student. I'm not an attorney or lawyer or an advocate. I'm just a student discussing cases and acting in good faith, i.e. bona fide. I'm discussing cases by making use of my knowledge as a law student and making use of my own opinion. Again, I'm discussing cases in good faith from a law student perspective. Alrighty, so for this video, I will be going through a court case. So therefore, this video will go under the RIA Cases at playlist. So under this playlist, you will find me going through court cases that interest me. Last week, I went through a South African case number 1. This one is South African case number 2. So feel free to check the videos under this playlist. This video is a continuation, so check out case number 1. So check out this video. So this video is a continuation. Alrighty, just a quick recap. Playing a pun on recap. So just a quick recap. Mel and Peet Viljoen started Tammy Taylor South Africa with permission from Tammy Taylor. In 2021, Tammy Taylor terminated the international distribution agreement that she had with the Viljoens. Even though Tammy Taylor terminated the Viljoens' rights in 2021, the Viljoens wrongfully carried on as if they still had Tammy Taylor's permission. Simply put, the Viljoens were infringing on Tammy Taylor Nails' trademarks, meaning the Viljoens were making unauthorized use of Tammy Taylor Nails' trademark. So essentially, the Viljoens were using Tammy Taylor's name without her permission because the distribution agreement was terminated. The case I'll be going through today has to do with Tammy Taylor Nails South Africa, Peet Viljoen, and Tammy Taylor Nails America. In my studies, I've come to learn that reading court cases is a very important skill for a law student to have. I look at case law as a collection of court cases that deal with important decisions that will impact future court cases. Just think of case law as a collection of important South African court cases. The module, Skills Course for Law Students, or SCL 1501, really helped me in understanding how to read a case. The case I'll be going through today is Faith Makabo versus Peet Viljoen. Pages 47 to 62 in the SCL 1501 study guide are incredibly helpful. When I'm looking for a case, I go to SAFLI, which is the South African Legal Information Institute. I have developed my own steps that I use when reading a case, and I really hope these steps will help you to note takers. I have dubbed these steps as RIA's 3 model case law steps. The first step in RIA's 3 model case law steps is finding the case. I've established that going to SAFLI will help in finding the case. The second step is to skim the case. When skimming, you check how many pages the case is, which court the case was held in, the name of the parties, and if the case deals with a certain act. The last step, step 3, is a deep dive. Step 3 is where I start to read the case. From the first paragraph to the last, I make super detailed and thorough notes, and where I find a paragraph I deem interesting, I write the paragraph number down. Writing paragraph numbers down, especially when you're doing an assignment, can be helpful. Hopefully, RIA's 3 model case law steps help you as you read court cases. Remember, step 1, finding the case. Step 2, skimming the case. And step 3, deep diving into the case. Let's apply RIA's 3 model case law steps to today's case. Step 1, finding the case. I made use of SAFLI, searched for the case, found it, and downloaded the case. Now, I can start reading the case. Next is step 2, skimming the case. The case is 10 pages. The case was held in the High Court. The parties are Faith and Peet Viljoen, who was trading as Tammy Taylor Nails. And the uniform rules of court are discussed. Uniform rules of court are rules that regulate the conduct of the proceedings of the provincial and local divisions of the High Court. Emphasis on High Court. Again, pages 47 to 62 in the SCL one 501 study guide are extremely helpful. And now step 3, deep dive. Step 3 is all about reading the case while making sure to write important paragraph numbers. Now that I know the parties and that the uniform rules of courts are needed, I can now dig deeper. The plaintiff can be described as he who issues a summons. In this case, the plaintiff is Faith Maka. From here on, I will refer to the plaintiff as Faith. The defendant can be described as he who is accused of wrongdoing. In this case, the defendant is Peet Viljoen, who is trading as Tammy Taylor nails. From here on, I will refer to the defendant as Viljoen or Tammy Taylor, South Africa. AJ stands for acting judge. The case examines how Faith, the plaintiff, is seeking a summary judgment. But what is a summary judgment? It is a court order where the court comes to the conclusion that there's no dispute of the facts. Summary judgment allows for a speedy judgment with no trial, and it helps to prevent expensive trials. To succeed with a summary judgment, the plaintiff is to show there's no dispute of fact and that the legal issues should be decided on the basis of the evidence before the court. Did the plaintiff succeed in getting a summary judgment? Did the defendant indeed act wrongfully? Let's start off with paragraph 1. Alrighty, paragraph 1 basically says the plaintiff seeks summary judgment in terms of Rule 32.1 of the Uniform Rules in the amount of 500,000. This paragraph deals with Rule 32.1 of the Uniform Rules of Court. Rules 32.1a and b state a plaintiff may apply to court for a summary judgment where a claim is based on a liquid document for a liquidated amount in money. Furthermore, Rule 32b highlights how a plaintiff bears the responsibility of verifying the cause of action and the amount claimed. So, Rule 32.1 says the plaintiff may apply to court for summary judgment if the claim is based on a liquid document or it's for a liquidated amount in money. Then Rule 32b says the plaintiff shall verify the cause of action and the amount, and why the defense as pleaded does not raise any issue for trial. The plaintiff must also show why a trial isn't necessary. Paragraph 2 explains how the 500,000 came into the defendant's possession. Faith paid 500,000 to Tammy Taylor South Africa Holdings on 16 September 2022. The money was for a franchise agreement. Remember, the case took place in the High Court. The High Court handles civil matters that deal with more than 100,000. This case deals with amount of more than 100,000. The amount dealt with in this case is 500,000. Paragraph 3 speaks to the plaintiff's acting in good faith. It was the plaintiff's understanding that once the 500,000 was paid, a franchise agreement would come about. Where a franchise agreement wasn't concluded, the plaintiff would be refunded. As we see here, The plaintiff paid $500,000 with the expectation that a valid franchise agreement would be concluded, and in the event it was not, that money would be refunded. But now the defendants are refusing to pay. An agreement wasn't concluded, therefore the plaintiff rightfully is owed the $500,000, but the defendants are outright refusing to pay Faith. Paragraph 4 explains the claims Faith has against each defendant. Against Peet Viljoen, Faith is claiming misrepresentation. Against Tammy Taylor, South Africa, Faith is claiming undue enrichment. Paragraphs 6 to 12 deal with the facts. I find paragraph 6 rather important. Paragraph 6 sums up how Faith met with Viljoen to negotiate a franchise agreement on 15 September 2022. Viljoen wrongfully represented to Faith that Tammy Taylor, South Africa, is a licensee of Tammy Taylor Nails, America. In my opinion, a licensee refers to a person or company that has a license to use something. Paragraph 7 shows the egregious behavior of the defendant, putting pressure on the plaintiff to enter into a franchise agreement. Basically says here, Viljoen persuaded her meaning Faith, to pay the amount of $500,000 so she could be in a better position for consideration as entering into a franchise agreement. So Viljoen presented it to Faith that if she paid the money as quickly as possible, she would get a franchise agreement as soon as possible. So in my opinion, Viljoen was putting pressure on her. Before moving on to paragraph 8, it's very, very important to note that the master license agreement between the Viljoens and Tammy Taylor Nails America was effective from April 2017 until its cancellation in February 2021, according to court documents. So, basically, the master license agreement between Tammy Taylor Nails South Africa and Tammy Taylor Nails America, it started in April 2017, but it was cancelled in February 2021. So because of its cancellation, Tammy Taylor Nails South Africa was normal. In my opinion, paragraph 8 is the crux of the case. The master license agreement with Tammy Taylor Nails South Africa and Tammy Taylor Nails America had been cancelled, meaning Tammy Taylor Nails South Africa lost the rights to use Tammy Taylor's name or logo in any way. Basically, Tammy Taylor Nails South Africa was no more because they lost the license to use Tammy Taylor. So, how are the Viljoens able to contract with the plaintiff, i.e. Faith, on 15 September 2022 when the agreement ended in 2021? As it says in paragraph 8, it would not have been legally possible. Surely Viljoen knew they couldn't trade as Tammy Taylor Nails South Africa anymore. So why did the defendants give Faith the impression that they still had the license to operate? Legally, once the master license agreement was terminated, the Viljoens couldn't use the trademark. If they were to use the trademark, they would be acting wrongfully. They would be acting malified. and it would be legal. The mere fact that Viljoen kept quiet and wasn't honest with the plaintiff is shocking. With paragraph 9, the plaintiff is showing that the defendants knew a franchise agreement wouldn't materialize because Tammy Taylor in America sent them a cease and desist letter. As it says here, the plaintiff pleaded that the defendants were aware of the termination because Tammy Taylor USA issued a cease and desist letter. So, in my opinion, with this case, a cease and desist letter is a letter warning one party to essentially stop using the other party's trademarks. So, Tammy Taylor America sent Tammy Taylor South Africa a cease and desist letter warning them to stop using Tammy Taylor USA's trademarks. So, because no franchise agreement was entered into, Faith demands the $500,000 back because a franchise for Faith can't materialize because Tammy Taylor South Africa don't have the authority to make that possible because the international distribution agreement was terminated. Remember, Rule 32B of the Uniform Rules of Court state that the defendant bears the onus of showing a bona fide defense to the action. As it says here, the defendant may satisfy the court that the defendant has a bona fide defense to the action. In other words, Viljoen or Tammy Taylor Nails South Africa must show a defense of good faith against Faith's claims of misrepresentation and undue enrichment. This is reiterated in paragraph 21. Paragraph 21 states, the question for determination is whether the defendants have disclosed a bona fide defense to the plaintiff's claims. Paragraph 27 shows Viljoen acted mala fide. It can't be bona fide as Viljoen knew the master license agreement had been terminated. Faith relied on the representation that the master license agreement was still operating. Because of her reliance on this representation, she paid the $500,000 because of Viljoen's representation, or rather misrepresentation. As it says here, Viljoen could not have been of the bona fide view that the representations were fact and true. The representations were material to the negotiations relating to the franchise agreement, and the payment of $500,000 was made by the plaintiff to Tammy Taylor South Africa as a direct result of those representations. Basically, paragraph 27 is saying Faith, because she relied on Viljoen's misrepresentation, that led to her paying the $500,000. Paragraph 34 shows the findings of the judge. Viljoen made false and unlawful representations, or rather misrepresentations, that the plaintiff relied on, leading to Faith paying $500,000 to the defendants in good faith. The judge said, I therefore find that the representations made by Viljoen were false and unlawful. Viljoen's misrepresentations caused the plaintiff to pay the money to Tammy Taylor South Africa, and as a result, the plaintiff suffered a loss. Viljoen is therefore personally liable for the plaintiff's loss and damages in the amount of $500,000. So as much as Viljoen tried to separate himself from Tammy Taylor Nails South Africa in an effort to avoid liability, the judge found Viljoen to be personally liable. The plaintiff's loss is Viljoen and Tammy Taylor South Africa's fault. But did the plaintiff meet the requirements needed for a summary judgment? In my opinion, yes. The plaintiff laid out her claims, namely misrepresentation and undue enrichment. The plaintiff stated the amount, $500,000, and the defendants failed in showing they acted bona fide. In essence, the defendants acted bona fide by not openly disclosing to Faith that, look, our master license agreement is over, so a franchise will not be possible. The judge also agreed Faith acted accordingly and made the following order. The judge said, I am satisfied the plaintiff has sufficiently explained her cause of action and her reasons are sufficient why the defense doesn't raise any issue for trial as required in terms of Rule 32(1)(b) of the Uniform Rules of Court. I find that the plaintiff has made out a proper case for summary judgment to be granted in her favor. This is the judge's order. Summary judgment in favor of the plaintiff. The amount of $500,000. The first and second defendants, i.e. Viljoen, Tammy Taylor and South Africa, are to pay the plaintiff $500,000. I agree wholeheartedly with the order and the judge's findings because the defendants acted wrongfully. Their master license agreement was terminated in 2021, yet they still kept operating, making Faith sign a franchise agreement in 2022 and making her pay $500,000 for a non-existent franchise. The defendants misrepresented themselves and were unduly enriched. So let's go back, because when we started, my main question was, did the plaintiff succeed in getting a summary judgment? Yes, she succeeded because she did her due diligence. As we see here, she laid out her claims, she stated the amounts, and the judge saw that the defendants failed in showing they acted bona fide. And as we see here in Rule 32(3)(b) of the Uniform Rules of Court, the defendants failed in showing a bona fide defense. So yes, the judge granted Faith a summary judgment. The defendants are to pay her $500,000 back. So a successful case, in my opinion. Alrighty, we've reached the end of the steps. I've gone through the case and analyzed it to the best of my ability. My analysis might not be perfect now, but I tried my best. Feel free to leave a comment in the comment section or share your thoughts by emailing me at rianotip@gmail.com. Also, make sure to check out my shorts on Tammy Taylor, Viljoen, and Peet Viljoen, as you see here. Also, check out my other video discussing South African case number 1. This is South African case number 2. And then my last video in the Tammy Taylor drama will be looking at the US District Courts and the court documents that deal with Tammy Taylor, America. If you're a regular viewer, you know I hate littering. My mantra has always been stop littering. Please stop littering, note takers. We only have one planet, so let's all do better, stop littering, and look after our planet. Don't litter, do better. Alrighty, I hope you guys enjoyed this video. Don't forget to comment, like, share, subscribe. I am the CEO/employee/boss, and this channel is my daily bread. It's my job, so help a lady out by subscribing. I'm on the road to 450 subscribers. I hope you guys will stay tuned and that you watch my new videos. In closing, I shall say first, thank you for listening. Second, don't litter, do better. And lastly, see you soon. Until next time.